Judge Middleton. I wanted to have a chance to talk with you. Are you Arian Fisk?
Yes, sir.
This is file 2534FY. I'm here at the courthouse with Chief Assistant Prosecutor Joshua Robert. Your attorney, Paul Gibson, is also here present with us. You're charged with possession of methamphetamine as a fourth habitual offender with a drug double. The matter was set for a pre-exam conference today. And Mr. Gibson went to the jail and said that you didn't want to come out of the cell and talk with him. So I wasn't clear what you wanted, so I thought I'd just ask you. There is a plea offer where the prosecutor would reduce the fourth habitual for a waiver and a bind over to circuit court for a plea to possession of methamphetamine as a second felony offender, which would be a 15-year felony offense. You also have a right to have a preliminary examination in this matter, but I wasn't clear what it was that you wanted me to do, so I thought I'd ask you. Are you declining the prosecutor's plea offer?
Yes, sir.
Would you like to have a preliminary examination?
Yes, sir.
All right, that'll be next Tuesday at 1 o'clock.
Your Honor,
Yes.
could you inform me if I've never been charged with possession, I've never been convicted of possession, how am I a second substance or second?
Well, that's a good question. Let's take a look at the complaint.
Another thing is I've never been heard on the PPO that they originally came out to the house for. So that means there was no original arrest to be made. That means there's no possession at all. They came out to arrest me on a PPO. That PPO was evidently dismissed. So that means there's no original arrest to be made. That means I have no possession.
Well, all right. That's certainly something that could be explored at the prelim. According to the charge, you were charged with operating a meth lab on April 17th of 2015.
That is not possession.
Well, it's a previous drug charge, so it qualifies under the statute. So your contention is that the pretext for the arrest was not valid, and we can certainly explore that.
Sure, that's what
All right. Well, you're right. It is not a possession, but it is a drug charge under the Public Health Code, which would qualify for second offense. And I don't know much about it because I'm not supposed to till we get there. So you have a right to a prelim, and we'll do it next Tuesday at 1 o'clock. Now, Mr. Gibson can't help you unless you talk to him. And so we can explore this, your conjecture that this arrest never should have taken place in the first place. But
Mr. Gibson does not represent me.
Who does represent you?
I do.
You have a right to represent yourself. There's an adage that it's a fool that has himself for a lawyer. You didn't understand the statute. You don't have a law degree. You don't understand the rules of evidence, and you are facing a potentially 20-year prison sentence or worse. But we'll discuss it further. For the time being, Mr. Gibson is still there, at least in an advisory capacity. We'll make a determination of whether you can represent yourself. But you've got some complicated issues. If your contention is that there was no PPO and
there was a PPO, but I have not been arraigned on that PPO. That means that
All right.
PPO, it did not exist. So that means there is no original arrest to be made, therefore there is no possession.
All right, how are you gonna establish that?
I just did.
No, you didn't. You just said it. That doesn't mean that it's accurate. I believe you could use some help from a lawyer to run some of these things down. They
I
can
can
actually
use-
get the files, look at it and see it. So for
I can use
now,
help from-
I indicate that you wish to represent yourself, but I haven't made a determination yet. Ultimately, you have a right to do that. But I
That man
think
is
you
not
could,
adequate. I have asked for that man not to represent me. And they appointed him anyway. There's a conflict of interest between me and that man.
what's that about?
It was in our last case versus Patterson, which was 4 months ago. The man called me incompetent, told me I was mentally retarded. I said that man does not represent me. That was on record. And then they tried to have him represent me this time. I said, I do not want that man. They said, well, what's the problem? I said, that man and I have a conflict. Well, that's not a conflict. I said, yes,
All
it
right,
is.
so you would accept counsel, but you don't want Mr. Gibson.
Yes.
Okay.
But I want it on record that the police were called for a personal protection violation. They showed up, they detained me, they searched me, said that they found me to be in possession. I was not heard on the personal protection order. So that means that there's no arrest to be made.
Well,
That
there's a
means all
difference
evidence
between an
is fine.
arrest and search, but all right, I hear where you're coming from.
Okay, thank you.
Mr. Gibson, you have any further input regarding this? He indicated you and he had a bad relationship in the previous case.
I don't recall any incident that he was referring to. I guess I'd have to go back and check my records, because I don't recall.
Well, the notes indicate that he told Judge Pattison he wanted to represent himself. All right, Mr. Fisk, for now, it's set for next Tuesday at 1 o'clock. My inclination is to allow other counsel.
Thank you.
Have a position?
I don't have a position on that.
You want to know what to do next Tuesday?
Right, because if he's gonna get a new attorney, new attorney is gonna say they're not prepared for a
Yes,
prelim.
correct. All right, I'll allow a new attorney to be appointed and reset the pre-exam
Thank you.
for next Tuesday for 9. Oops, that puts it on Judge Pattison's calendar, but I don't want to go 2 weeks because you're in custody. Reset PEC for 1/28/25 at 8:30 with new counsel. All right, you're good to go, Mr. Fisk.
Thank you, Mr. President. Thank you.